Hello again and welcome to QuickIP. Today we're dealing with grounds for refusal and opposition of trademark registration. This is step 3 on our map or timeline. We dealt previously with requirements for trademark protection, and you remember that we did say that you require registration of a trademark in order to enjoy the trademark rights and the protection that trademark law grants. And so now we're dealing with you filed an application to register a trademark. To your mind, you believe that you have a mark within the meaning of the trademark law, and that mark has been used, or you intend to use that mark in relation to goods or services, and you believe that the mark is capable of, or you're using the mark for the purpose of distinguishing your goods or services from those of another. And now it's possible that when you file the application, that the Registrar of Trade Mark says no, based on certain grounds, your mark will not be registered. Now I'm going to refuse registration. It's also possible that when they advertise your mark in the patent journal, in the case of South Africa, and in the trademark journal, in the case of other jurisdictions, when they advertise your mark in the journal and say this is a mark that someone wants to register, at their opposition to the registration of this mark. Some people might look at your mark and say, no, this mark should not be registered. We are going to oppose the registration. And so we want to discuss what are those grounds that the Registrar of Trade Mark can rely on to refuse registering your mark? What are those grounds that other people can rely on to oppose your registration and maybe succeed, or hopefully not, depending on which side of the divide you fall under. So the grounds for refusing the registration of a trademark or opposing the registration of trademark in the case of South Africa, you can actually house them under 4 broad categories. It's either the mark in question doesn't have intrinsic registrability, we'll deal with that subsequently, or that the mark is a prohibited mark, or that the person that want to register the mark, you are not the proprietor of the mark, and there's no good faith in your proposed registration, or the mark that you want to register is actually subject of third-party rights. Those are things that could prevent or lead to the opposition of the registration of your mark. So let's deal with each of them specifically. So let's see, there could be a situation where your mark they say that your mark doesn't have intrinsic registrability. In this case, you're dealing with the fact that they are saying that your mark doesn't satisfy the requirements that we previously dealt with for trademark registration. So they are saying that this is not a mark within the meaning of the trademark law, or they are saying even though it's a mark, it's not distinctive, it's not capable of distinguishing. Or they could be saying, well, this mark that you want to register constitutes a shape or a configuration that is necessary to obtain a technical result. So let's say, for example, let's use color as an example. Chocolate would always, because of the cocoa, would always take the brown color. So imagine you want to register brown as a trademark for a chocolate product. That's the color that is necessary to obtain a particular a technical result. That's also the same scenario when the color or configuration or pattern or shape that you want to register is likely to restrict development of art or industry. Let's say you want to take a particular let's say green for agricultural products, for example, because of the color of leaves and trees and all that. And now you want to take over that color or the shape of a leaf for agricultural products without anything more other than just the shape of the leaf. They could consider it as something that is likely to restrict the development of that particular industry. So in that case, or when let's say your mark is misdescriptive, you are the way that the mark, when the mark is applied to the good, it's giving it's creating a different perception or impression that is actually misdescribing. It is not it's deceiving, or it's presenting a false picture to consumers. Then in that case, they will say that this mark, it doesn't have intrinsic registrability in and of itself. It doesn't, it will not work. Then they could also come and say the mark is a prohibited mark. When you're dealing with a prohibited mark, there are marks that within the law, within the trademark law, it is a mark that is prohibited. Let's say things like national flags and symbols. So you want to use the map of South Africa as a mark. It's prohibited. You're not allowed to use it. Or you want to use a mark that indicates state patronage when do such things. In fact, it is prohibited. You want to use a mark that specifically in the trademark regulations, they have the Registrar of Trade Mark, who makes the trademark regulation, has prohibited that mark specifically. Then your registration will not go through. It will be refused or successfully opposed. Then it could be an instance where you're dealing with the fact that you are not the proprietor of the mark. So you are not, let's say it's not your company, it's not your mark, but you want to now apply for registration. They will say no, you are not the proprietor, or there's proof that you don't have any bona fide or good faith intention to use the mark. Let's say that's what usually happens when you talk of people that preemptively register a mark. They are not intending to use it, but they can see that they want to block someone. So let's say you see a nasty C that wants to, because you've seen as nasty C is popular, you don't intend to run any business, but now you go and register a nasty C, a trademark with nasty C, just because you want to, you don't have any good faith intention to use the mark. You just want to make sure that by the time nasty C comes to maybe start a merchandising line or a perfume line or a clothing line or whatever line, and he now wants to use nasty C because that's his performance or performing name, he would find that it's no longer available, and then they are supposed to come and beg you and pay you money so they can use the mark. So there's no good faith intention to use the mark. In fact, there's bad faith, because now you want to prevent someone that could have used the mark from using the mark. In that case, they could successfully oppose your registration of the mark. It could also be that the mark is subject to third-party rights. So, for example, in a case where you have a Paris Convention well-known marks. Now, this is a mark that is in another country, Paris. I don't like saying Paris. They say it's Paris Convention country, just like South Africa, and they have a well-known mark there, and you now want to register that same well-known mark in South Africa, you could be successfully opposed that this mark is subject to third-party rights. Or let's say the mark you want to use is inherently deceptive, it's likely to give offense, it's contrary to law. So in a case where the mark is an abuse to a particular race or tribe or something like that, then so the third party right in this case would be the right of maybe personal dignity, the right to dignity, protected in the Bill of Rights, and the right against discrimination and all that. And then it could also be that the mark is confusingly similar to previous trademark application. So maybe you see that someone has applied, not that someone has registered, but someone has applied for to register a particular mark. Now you want to also bring in your own. They will say no, there's an existing application that we're still even processing, and so we will not allow you to register this mark. Or let's say the mark is contrary to the existing right of I said the mark is contrary to the existing right of a third party, or let's say in a case where it's confusingly similar to a mark that is well known in a particular country. For example, a mark that's well known in South Africa, it's confusingly similar to it and it's going to cause economic harm. Then the application for the registration of the mark could be successfully opposed. To recap, when you file an application for registration of a mark, the registrar could refuse the marks by the registrar could refuse your application for registration and of course refuse to register the mark, or someone could successfully oppose, or even if not successful, at least oppose the marks. And if they are going to do so, it will be on these grounds that the mark doesn't have intrinsically, the mark is not registrable because, like what we said, or the mark is prohibited in law, or you're not the proprietor of the mark and there's no good faith on your part, or that the mark is subject to third-party rights. And if they can successfully establish any of these grounds, then your mark will not be registered. Where the registrar refuses the registration, of course, if you're going to appeal that refusal, you are going to rely on the fact that actually those grounds that the registrar relied on, or those grounds that was successfully relied upon by the opposition, do not actually fall within this any of these categories that we've mentioned, and so that your registration should actually have happened or should have actually been allowed. But there you have it, the grounds for registration, refusal, or opposition. We'll stop here for now and we'll talk more in class. Bye.